now in the hands of a federal judge to the fate of Illinois' gun and magazine ban. Welcome in. It's Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell with America's Talking Network, and get the headlines at thecentersquare.com. And if you go to the Center Square, you'll be able to access some of these briefs, but you can also follow me on X. Just search Bishop on Air, and you should be able to find where you can download these briefs yourself. But let's get right on into it. Of course, the Protect Illinois Communities Act was enacted in January of 2023. Federal lawsuits filed shortly thereafter. Last year, if you recall, in the district courts, when these cases were consolidated, Judge Stephen McGlynn issued a preliminary injunction, essentially an initial move to block the law from being in effect for 6 days before the state appealed to the Seventh Circuit Appeals Court, and the Seventh Circuit put a stay, essentially holding McGlynn's order from being effective until they dealt with the issue on preliminary grounds, right? So this was all just preliminary grounds, not on final judgment. Well, last year, the plaintiffs then appealed to the U.S. Supreme Court, which then later on, earlier this year, replied back and said this was on preliminary grounds. We'll take a gun ban challenge if it's on final judgment, but not until then. So ultimately, all of those cases went right back to the district court. Last month, in McGlynn's district court in East St. Louis, he held a 4-day bench trial, hearing from experts from both sides of this. They tackled the issues that the Seventh Circuit really addressed, which they said the state had a likelihood of succeeding on the merits because these banned firearms, like an AR-15, are too similar to military-grade firearms. So during the bench trial, a lot of conversation about that particular issue. But then at the end of the trial, after McGlynn reflected on the race riots of 1917 in East St. Louis, talking about how things may have been different if the black victims in that case had firearms to protect themselves that were being debated during the bench trial. So it was an interesting kind of revelation of sorts of how McGlynn could rule in that case. But now, here we are, the 30-day window expiring for when McGlynn gave the litigants the deadline to file their final briefs. And what we have are proposed conclusions of law and proposed orders from both sides. And we'll bring up Todd Vandermyde here in a moment, but I did want to just quick overview of what we're looking at here. And if you follow me on X, you can see where we posted the links and the various arguments that are being made here. So the state filed 3,500 pages of exhibits and the proposed findings of fact and conclusions of law. Just some bullet points here. Among those proposed findings, they say firearms, accessories, and ammunition banned by the law restricts those arms are useful in military service and unusually dangerous, they say. The AR-15 platform rifles, the act restricts, are functionally identical to the M16 and M4 rifles. They go on to say the AK-47 is functionally identical to the AK-47 rifles used by militaries around the world. They continue on talking about 50 caliber rifles. They talk about many of the pistols the act restricts are either AR or AK platform firearms or semi-automatic versions of submachine guns. The shotguns the act restricts are a narrow subcategory of large capacity semi-automatic shotguns. Firearms and large capacity ammunition devices the act restricts are not commonly used for lawful self-defense, the state argues. And then they go further to unpack all of that. You can look at it yourself and find those bullet points. Again, go to x.com/bishoponair for those posts. But they also argue in their final pleading here that if the state issues an injunction, or if the federal judge issues an injunction, they say it should be limited in scope and should be stayed pending appeal. Plaintiffs are not entitled to a permanent injunction because they've not prevailed on their claims, the state argues. If this court disagrees, however, any injunction it enters must be limited in scope and should be stayed pending review by the appellate courts. So clearly, the state's trying to hedge any potential ruling from McGlynn, asking that he put a stay on his ruling if it indeed is a final judgment order striking down the law. But then we had the plaintiffs file their briefs, and in a general plaintiffs' proposed findings of fact, they spell out in some detail, and we'll just look at the table of contents here. The findings of fact, of course, Protect Illinois Communities Act. They say that the plaintiffs do have standing to challenge it. They talk about the various devices, PICA bans that are owned by ordinary people and do not. And they do keep those to use for lawful purposes like self-defense. But then you get to the proposed conclusions of law, and they say the firearms and feeding devices that PICA outlaws are arms, and they argue no historical tradition justifies the Protect Illinois Communities Act. So that's just one plaintiff's filing. Then you get to the Langley plaintiff's filing, and there you've got some interesting things that attorney Thomas Magg argues here, and he even brings up the issue that McGlynn raised at the tail end of the trial. He says that the court, at the close of the live portion of the evidence, recounted with accuracy the history of the St. Louis riots from over 100 years ago. This recounting hits the undersigned with a high degree of personal interest, having been familiar with the story. The court asked, perhaps rhetorically, perhaps not, how things might have been different if the victims of that riot had possessed a few of the arms at issue in the case. Said another way, what would have happened if a few of the potential victims, not even all of them, had been reasonably well armed? So an interesting argument there with the Langley plaintiffs reminding the judge of what he had to say. But then we get into the Federal Firearms Licensees of Illinois filing here, and they argue that the registration is a violation. They argue that the restriction on parts are a violation. And here you'll see one particular line relevant for our next guest. It talks about how, by banning firearms, it precludes Illinoisans like Mr. Vandermyde from being able to keep their firearms in working order or suited to their needs, so that they can maintain proficiency in their use. And it cites the Rhonda Ezell case on that front. So let's go ahead and bring up Todd Vandermyde. He joins us now to kind of give his reaction of what happens next in this case. Todd, thanks for taking time with us this morning. Of course, the briefs from the plaintiffs filed late last night. I only saw them early this morning when I got up at 5. But, where are we at in this case, and where do we go from here?
It is all up to the judge. So just like when you listen to Supreme Court arguments, and the orals are done, and Justice Roberts says the case is submitted, that's where we are. The case is submitted to the judge. He has everything that anybody is going to throw at it, and it's now in his hands, and we'll see what he rules. I mean, we think we're going to get a positive ruling based on things that he has said in the courtroom and based on the way he ruled on the injunction. But the judge has a difficult task because the Seventh Circuit has come up with these two made up tests that they just conjured out of whole cloth. They have the test of, are they arms because they have some military connection, look, whatever, and that they must have been used in self-defense, which is found nowhere in Heller, nowhere in McDonald, nowhere in Bruin. And this is the same thing that the Fourth Circuit did in the former Bianchi, now Snope case. They keep making up this militaristic test, which, based on what, if this had been litigated in 1791, then the muskets the militia members brought to muster would have been illegal. They would have been able to own those. There's always, and the funny thing is, they ban guns like the AR-15 that have never been used in a formal, army setting, but yet the 1911 is perfectly fine to own, and that was adopted by the military. So they're schizophrenic on this. But that, we're in front of the judge. We'll see how long it takes the judge to rule. If memory serves me correctly, on the preliminary injunction, he did something in about 3 weeks. And all the timing on this is going to get very interesting because it's the 22nd today. The judge has the case. And now we know that on the 12th of November, what is that? 3 weeks, less than a month, 3 weeks or so, Viramontes is going to be argued in front of the Seventh Circuit Court of Appeals. So what's going to come out of that? What are those orals going to look like? One, does the same panel that had our case, Beavis, and this whole menagerie of challenges, do they just think that Viramontes is a just different side of the same coin? And do they take it as a comeback case? Is it a fresh panel? If it's a fresh panel, who's on the panel? Does Easterbrook elbow his way in there to have another, round of influence on his preposterous standards?
Todd, obviously, a lot's going to happen after any kind of ruling comes, but you're predicting we could see something within 3 weeks.
Well, that's how, you think you were there for the preliminary injunction stuff. You saw how in depth it got, and it wouldn't surprise me. I mean, my hopes are that Judge McGlynn sits there and writes a very favorable opinion in our case and towards our side. And we get a very broad ruling on that. And he just happens to have a sense of humor, and he sits there and releases the case at 4 o'clock on Wednesday before Thanksgiving in front of a holiday weekend, and gives us a freedom weekend to include Black Friday. And, the state is left scrambling through a holiday weekend to try and get, in front of an emergency order in front of the Court of Appeals. And it gives us the ability to have a freedom week where some of those firearms that have been locked up since the last injunction because they couldn't be transferred get transferred, and we go from there. We could, it's any, I have a whole bunch of theories and thoughts about what happens with Viramontes. Does the appellate court try to rush an order out in order to block or subvert anything Judge McGlynn would plan on writing? Because Viramontes was a merits decision that was hostile to us. So we've got that. And Viramontes will be argued before Bianchi, now Snope, goes to conference. And we won't see, what the outcome of the Supreme Court is going to be probably before the first week of December or possibly a little later. And what happens then? So if the Supreme Court takes cert and we don't have a decision in McGlynn, does McGlynn hold? If the Supreme Court takes cert in Snope, does the Seventh Circuit pause their decision in Viramontes? Um, I'm sure that if we get a decision out of McGlynn and it goes forward, and the state appeals a bad decision, then I'm sure that if the Supreme Court grabs certain Snope, then our side will more than likely ask the Seventh Circuit for a stay, saying there's no reason to argue this until we see what the Supreme Court's going to do. So those are all the moving pieces that could affect our case in Southern Illinois.
Todd, your thoughts on the state asking for a stay if McGlynn issues a not a preliminary, a final judgment injunction? Is this just the kind of their last ditch effort, or how do you perceive this?
Our arguments are so bad. Please give us a chance to get to the Court of Appeals. That's what it says. I mean, they're reading the room the same way I'm reading the room, I guess. I mean, I'm sitting here and I've been saying I think we're going to get a positive opinion out of Judge McGlynn that's I think it's going to be like Benita's, well reasoned, well thought out, detailed, annotated. And I think they kind of, you heard what he said in that closing statement. I think they read the tea leaves and they know they're going to lose. And that's why I think this, 3,500 pages was one possibly a way to slow it down. Because if, let's say that McGlynn sat there and issued a decision in a week. Oh, he had it written. It was pre-done. He didn't give us the benefit of our briefs, or there's no way you could have gone through 3,500 pages, whatever.
Yeah, of exhibits. I mean, but McGlynn's even said he didn't want to be papered to death at one
You were
point in
there.
this
You
case.
heard it right alongside me. And what does the state do? Just the opposite. So, I mean, growing up, when your mom said, don't do that, did you go ahead and do it anyway just because you wanted to test the boundaries or what?
Yeah.
I mean,
well, Todd, finally here, I mean, obviously, you've got this Illinois case at the district level, final judgment expected soon. It's going to go to the appeals court. But, as far as the Snopes case in the Supreme Court, clarify for us, if you could. Does that deal with magazines? If it doesn't deal with magazines, what does that mean for, Illinois' law?
I don't think, as I've read it, I didn't see much of a reference to magazines at all. I think Snope might be a clean gun ban case only. I'll have to go back and reread it. But we've got so many of these things floating around, they kind of get lost and jump. But you have Duncan that's ahead of us on magazines right now, but the Ninth Circuit is playing their typical games with the magazine ban in California. There was a magazine ban out of Jersey, and I don't know what the status on that one is, but the stuff is all starting to bubble to the surface. So we could go on magazines, but they could make a passing comment on magazines and Snope and just say, hey, because remember what we're talking about. We are talking about semi-automatic firearms, and the ones they really hate are semi-automatic firearms with detachable magazines. So I think the court, in delineating what weapons are protected, is going to have to touch on magazines one way or the other. Now, could they parse it and say semi-autos that take detachable magazines are protected, and then turn around and just leave it at that and do something, and come back for another day? Very likely. Very likely, because if you notice, they're taking small bits and pieces. They remanded another case yesterday. There was a felon in possession case that got GVR'd yesterday from the Supreme Court. So they're doing this stuff in small bites.
Definitely something we're going to be watching closely, as I know Todd Vandermyde will, as well as somebody in the briefs here as the conclusion of litigants telling the judge what's up in this case. And obviously, Todd, people can stay updated with your thoughts at Freedoms of Steel on YouTube. Greatly appreciate you taking the time with us this morning.
No problem, guys. Take care, Greg.
All right, it is Illinois in Focus with another update there, and we'll be watching closely as to what happens in this case. But clearly, there's a lot of moving pieces, as Todd said. So be sure to stay tuned, like, subscribe, hit that notification bell. Join us each and every weekday morning for Illinois in Focus Daily. Get the podcasts anywhere you get podcasts. And also, don't forget, you've got the headlines at thecentersquare.com. thecentersquare.com. It's Illinois in Focus Daily.